sued by a third party to a contract. As per the Indian Contract Act, the consideration for an agreement can be proceeded through a third party. Okay, that means a third party can pay the consideration, but the third party cannot sue on the contract. That means he cannot sue any party to the contract. Only a person who is a party to the contract can sue on it. Like if any third party is involved in the contract, if he is not a party to the contract, he cannot be suing other parties. The concept of stranger to a consideration is valid and is different from stranger to a contract. So as we already understood in the previous content, the consideration cannot be from can be from a stranger, but there cannot be a contract from a stranger. So in the example that we have seen, P, who is indebted to Q, sell his property to R, where R is promising to pay off the debt to Q. If R is failing to pay, then in such situation, Q has no right to sue. So understood? Here what happened? P and Q are the parties to the contract. Okay. So P is indebted to R. So he is selling his property. He is selling his property to R, where R promised that he will pay off the debt which Q has to pay, which P has to pay to Q, that R is promising that he will pay to Q. So in that situation, Q cannot directly go and sue R for the payment of debt. Here we just said that the stranger to a contract cannot sue as per the doctrine of privity of contract. Okay, there could be a stranger to a consideration, but there cannot be a stranger to the contract, we just said, because the third party cannot sue the parties who are involved in the contract. Okay, this is what is said as in doctrine of privity of contract. Okay, but for this rule there are few exceptions. The following are the exceptions: that in case of a trust, okay, if there is a trust created, a beneficiary in the trust can enforce his right though he was not a party to the contract before between the settlor and the trustee. Okay, even though if the beneficiary is not a party to the contract, he will be having the right to clear the dispute between the settlor and the trustee. And in the case of a family settlement also, if the terms of the settlement are reduced into writing, then the members who are involved, right, the members of the family who are originally not the parties to the settlement, but they can also enforce the agreement. That means in the social agreement where there is no contract between the parties, like whoever the members of the family are there, were actually not the parties to the contract, but they can enforce the agreement. This is the exceptional case to the rule of doctrine of privity of contract. See, as you can see in the example, two brothers X and Y, they have agreed to pay an allowance of 20,000 to the mother on the partition of the joint properties, but later they denied to abide by it. That means they haven't paid that 20,000 allowance to their mother. Then the mother, being a stranger to the contract, she can go and sue the brothers in the court of law for getting such allowance. Okay, she can sue their sons for getting the allowance in the court of law. In case of certain marriage contracts or arrangements, a provision can be made for the benefit of a person. He may file the suit though he is not a party to the agreement. Okay, if any party who is a stranger to the contract can also file a suit against the parties in the contract in case of certain marriage contracts or marriage arrangements. We'll see in the example, Mr. X's wife, she is deserted him for ill-treating her. Then Mr. X has promised a wife's father, okay, he is Mr. Puri, like Mr. X's wife's father, okay. So Mr. X has promised his wife's father, Mr. Puri, that he will treat her property or else pay her monthly allowance. He said he promised that he will pay her monthly allowance or he will treat her properly. But she was again ill-treated by her husband. Held here, the Mr. X's wife can sue Mr. X now, as she, even though she is not a party to the contract, she has the right to sue Mr. X. Okay, the contract is between Mr. X and Mr. Puri, but the stranger who is Mr. X's wife can also sue the Mr. X. Yeah. So in the case of an assignment of a contract, one party is assigning something to the other party. In such cases, in such contracts, the assignment should not be involving any personal skill. Then we can say that the assignee can enforce the contract. Okay, there are two parties to the contract. The one party who is assigning something, the assignment to the other party. So this other party who is assignee, if there is no involvement of personal skills, we can say that the assignee can enforce the contract and he can sue the parties to the contract. Okay, and also in the case of acknowledgement or estoppel, where the promiser, by his conduct, okay, by his act or performance, he is acknowledging himself as an agent of the third party. Okay, there's one party who is third party. Under him, this promiser is saying that I'm acting as an agent to the third party. He himself is acknowledging that, he himself is saying that, then it will result into a binding obligation towards the third party. Okay, as he is telling expressly that he is an agent of the third party, then there is a contract which can be enforced between those two people. Okay, the promiser and the third party. Okay, now here if you see in the example, L is giving to M rupees 20,000, but which actually had to be handed over to N, and M informs N that he is holding the money for him. That means M also informed N that he is holding the money for him, but afterwards when the situation of paying the money, M refuses to pay the money. Okay, then N can enforce the contract. Okay, here in this case N is actually the third party, but here N can enforce the contract, then he can sue M for getting the money recovered. Next, in the case of covenant running with the land, that means if there is any agreement or contract, written agreement or contract running with the land, the person who is purchasing the land with notice that the owner of the land is bound by certain duties which affect the land, then the covenant affecting the land may be enforced by the successor of the seller. Okay, see here the person who is purchasing the land is having the notice of few things for which the owner of the land is bound to perform. The owner has some obligations with regard to the land that he needs to perform. Then in that situation, the successor of the seller can enforce the contract between the two parties. Okay, who is a third party can actually enforce the contract here. The successor of the seller, he is the third party in this contract, but he have the right to enforce the contract. See in the example, one owner of the land is having two lands adjacent to each other. Okay, just beside each other, he is having two lands. One was agriculture land. He sold the other land containing a condition that it can never be used for industrial purpose, so as to protect the agriculture land from pollution. Okay, so he has two lands, right? One is for agriculture land and the other is for other is a general land where we cannot do industrial works, industrial purpose, it will not work at all. So that he has it for not making any pollution to the just beside land which is agriculture land. Such condition is attached with the land, so whosoever is the successor of the land has to abide by it. So whoever is purchasing the land which cannot be used for industrial purpose, he has to abide by the condition. So these are the restrictive covenants and all the successors are bound by it. Whoever is purchasing this land, they should be binding by this condition. Actually, the successor is a third party. He is not entered with the contract. He is not there when the agreement, the restrictive clause is written in the agreement. But in this case, whoever is purchasing the land will be the successor. Then he has to abide with the conditions. Okay. Even though if he is a third party, he has to enforce the contract. Next is the contracts entered into through an agent. So here there are two parties, one is principal, one is agent. Okay, agent is working on behalf of the principal. That means he can sell goods or he is entering into some contracts on behalf of the principal. Okay, he is not entering into contracts with his own name, but he is entering on behalf of the principal. Then we can say that whether agent is acting within the scope of the authority of the principal and in the name of the principal, here the principal can enforce the contract. Okay, being third party, the principal has the right to enforce the contract based on the on behalf of whom the contract has been entered, right? So the agent who is entering into the contract on behalf of the principal, so the principal can enforce the contract here.